Thank you very much, Omar, and good afternoon to everyone. I hope you had a good lunch. I'm delighted to have been asked to chair this third panel this afternoon, which is titled The Threshold Determination, Its Interpretation and Application at the International Criminal Court. I'm Akbar Khan. I'm the Director of the Legal and Constitutional Affairs Division of the Commonwealth Secretariat. So therefore, I'm particularly pleased to be here at the Royal Commonwealth Society. I'm joined by a distinguished legal panel who will discuss this issue for us this afternoon. I will start off with Professor Chandra Sriram, who is on my far right, just to introduce the panel before they make their presentations. Professor Chandra Sriram is Professor in Law. Her areas of teaching expertise include war and human rights, public international law, international criminal law, human rights and conflict prevention, and post-conflict peace building. She's the author and editor of various books and journal articles on international relations, international law, human rights, and conflict prevention and peace building. She will then be followed by Dr. Sarah Nouwen. And Dr. Nouwen, who's sitting on my left, is a university lecturer in law and fellow of the Lauterpacht Centre and Pembroke College. Sarah's research interests lie at the intersections of law and politics, war and peace, and justice and the rule of law. And she's published articles on the politics of international criminal justice, peace building, mixed courts, complementarity, the responsibility to protect immunities and justice in Sudan and Uganda. And as a plug, she has a new book coming out, The Catalyzing Effect of Complementarity in the Line of Fire, the Effect of the International Criminal Court in Uganda and Sudan. Followed by Sarah will be eminent Silk Karim Khan, no relative, we have no interest here. But Karim is, of course, very eminent Queen's Counsel who practices at the international courts. He's a British barrister, a member of Temple Garden Chambers, combines a practice at the national and international levels in public law and human rights, and specialises in international criminal law, acting on behalf of governments, heads of states, political leaders, military officers, and victims before all the international criminal courts and tribunals. Among other individuals, Karim presently represents Mr. Abdullah Banda and Mr. Saleh Djerbo in the Darfur situation before the International Criminal Court, as well as Ambassador Francis Kirmi Muthara in the Kenya situation before the ICC. And then last, but certainly not least, to my far left, is Sir Geoffrey Nice QC. And many of you will know Sir Geoffrey from his reputation as a prosecutor in the Milosevic case at the International Criminal Tribunal for the former Yugoslavia. Sir Geoffrey was called to the bar in 1971. He took silk in 1990. He has a formidable reputation in the international criminal field. In 1998, he was recruited to International Criminal Tribunal for the former Yugoslavia by then Justice Louise Arbour, later High Commissioner of Human Rights. He prosecuted the ICTY's then biggest case about a mid-level politician, Kordic, and the ICTY's first case to reach a conclusion charging genocide, Jelicic. And then he returned to The Hague in November 2001 and led all Milosevic team from there onwards until the end of his trial. More recently, Sir Geoffrey has appeared for the Sudan Trade Union, together with the NGO SIDG, in applications and attendances at the International Criminal Court in the Darfur situation cases. And together with Rodney Dixon, who we heard on the panel this morning, panel 2, he and Rodney have found ways into the ICC system by use of the ICC's own laws and regulations and rules permitting representations to be made on behalf of citizens of a state that has not been prepared to cooperate with the court. So a very warm welcome to the panel. The panel, the issues we will be addressing primarily fall within Article 17 of the Rome Statute, which go to the admissibility of cases and situations before the court. And Article 17 in particular talks about when the court shall determine that a case is inadmissible, and within that context where a state is unwilling or unable genuinely to carry out the investigation and prosecution. The case has been investigated by a state which has jurisdiction over it, and the state has decided not to prosecute the person concerned unless a decision resulted from the unwillingness or inability of the state genuinely to prosecute. The person concerned has already been tried for conduct, which is the subject of the complaint. or the case is not of sufficient gravity to justify further action by the court. My first question is directed to Chandra, who is going to talk to us about the gravity threshold and the International Criminal Court's assessments in DRC, and we'll touch on the Kenya case as well mainly the Kenya case, and touch on the DRC situation also. Chandra, the gravity threshold has played a crucial role in guiding the prosecutor's selection of cases and situations. In particular, gravity played a key role in the prosecutor's explanation in his first case in Uganda, where he stated that the crimes committed by the Lord's Resistance Army were much more numerous and much higher gravity than those allegedly committed by the Ugandan People's Defence Force. And in 2007, the prosecutor's paper on the interests of justice refers to the prosecutor's consideration of the gravity threshold. And just to quote you, he says, "In determining whether the situation is of sufficient gravity, the office considers the scale of the crimes, the nature of the crimes, the manner of their commission, and their impact." We'd be happy to hear your views on how the prosecutor has applied those criteria with regard to his assessments in the DRC and Kenya cases. Thank you.
Okay, well, thank you very much, and obviously thank you to yourself and to Tomas and the organisers generally at the Royal Commonwealth Society. I suppose the first issue, and I think this will go to many of the topics on the panel, so maybe I should just put this out there, is why it is we have these limiting criteria for admissibility in the statute at all. And I think it is important to understand that the ICC has and was always understood to be a court that would handle situations in which where national courts could not, and that it wasn't understood to be a court that was really, in some senses, a global court, that it could never, for sort of financial and logistical reasons, handle all situations. And so I think gravity has to be read in that context, because otherwise there's something really nonsensical about the idea of the gravity criterion, period, right, which is that by definition all of the crimes in the statute are obviously grave, right? I mean, we're talking about war crimes, genocide, and crimes against humanity. So there seems to be something rather perverse, actually, about drawing a line and saying, well, these crimes actually aren't of sufficient gravity, when in fact, or if in fact, all of the other criteria are met, right, for the particular elements of any of the given crimes. So I just wanted to sort of put that out there, because I think that will probably come back to us in later discussions. But part of the problem is that, having said that, and understanding perhaps the underlying rationale for having gravity as a limiting aspect of admissibility, is that the statute doesn't tell us much else, right? It doesn't actually tell us then how we're to determine in any way what is more or less grave. And so we've seen the difficulty, in fact, in the Lubanga situation, where the pretrial chamber tried first to suggest a number of criteria focusing on crimes being systematic or large scale, focusing on the element of leadership, and focusing on the level of social alarm in the international community. And I think for a variety of reasons, these weren't considered wildly compelling criteria, and indeed the appeals chamber overturned them. So we were left again with this sort of open question. It overturned them without really explaining why. So we're left with an open question, well then what does constitute sufficient gravity? And the prosecutor himself has asked this question quite openly. I think the first time publicly in a lecture in 2005, in which he said, well, is it just the number, right? Is that actually how we decide? And I think he was asking the question, perhaps honestly, because he was mulling it over, right? Because on what basis are we going to actually make this differentiation? And he lent credence to the idea or the suggestion or the supposition by a number of people that perhaps it was based on the sort of numerical scale that we should be assessing, when in 2006 the Office of the Prosecutor issued a paper explaining why they were declining to pursue investigation in relation to two situations, in this case crimes committed in Iraq and crimes committed in Venezuela. I'll set Venezuela to one side because that was really about temporal jurisdiction. But with regard to crimes committed in Iraq, one of the rationales that was very clearly put forth sounded a lot like numbers or scale, right? It was very much down to, by the time you narrow it down to crimes committed by British forces in Iraq, where there would be jurisdiction, and there would be temporal jurisdiction as well, you're dealing with actually quite small numbers, possibly a dozen crimes. And he put this in stark relief, or the paper put this in stark relief to the scale of crimes in the Democratic Republic of Congo, for example. So I think that left many people thinking that gravity is about numbers. And obviously leaving us with some rather morbid and difficult questions that we would actually have to ask. But that's actually not where the story ends. In fact, in 2007, and you've referred to the 4 criteria that were then spelled out in the paper by the Office of the Prosecutor, we get slightly more detail, although I have to say perhaps not as much guidance as we might hope if you start to sort of dig under the surface of each of the criteria. So as you've noted, scale of the crimes, although notably not just a numerical threshold, but also the intensity. And this might be temporal intensity or a number of other things. The nature of the crimes, the manner of their commission, and their impact on victims and families. Now, I think these are all incredibly important criteria. I wonder, though, given the nature of the crimes that we're talking about, how much they help us actually to draw a line and find a threshold. And at the moment, the utilization of these criteria has happened in the context of the approval of the opening of investigation to the situation in Kenya, in which, in fact, all of these criteria were applied and supported as, in fact, the situation in Kenya meeting these criteria. Now, I think that raises a number of interesting questions. I'm afraid the judges don't help us much because they don't provide a lot of interpretive language, but the story of how we get there is I think, somewhat important. The situation in Kenya was clearly the situation of post-election violence was clearly horrific, but it is true that by comparison in sheer numbers to the situation in, for example, the Democratic Republic of Congo or the situation in Darfur, it is much lower. And so there has been writing in the academic legal literature suggesting that Kenya would not have met the gravity criteria. Now, very clearly, applying these criteria, the judges have said that it does. Now, I think what's interesting and important is that they did, but they did only following a series of queries back to the prosecutor for more information, most notably about the organization of the violence during the post-election violence. And the reason that I think that's important is I think it may open a set of questions that we've been able to see with regard to the definition of crimes against humanity. Because Judge Cole's dissent suggested very strongly, or argued quite strongly, that in fact the organization of crimes was not sufficient to meet the definition of crimes against humanity. But I think what's potentially interesting is that there are a lot of open questions within the definition of gravity, if in fact we're using the nature of crimes and manner of their commissions as part of the criteria. Right, and so one of the things that I've started to query in some of my own research, and I think it remains to be seen how it will play out, is whether we might end up seeing a convergence of some of the limiting definitional aspects of crimes against humanity with those that are in the gravity definition, which of course is simply guidance by the Office of the Prosecutor, but has been adopted by judges in the context of the Kenya situation. What's interesting, of course, is that the judges did, in fact, ask for more information from the prosecutor, and when the prosecutor came back in his response, he emphasized the manner of the commission, particularly the organization, focusing very much on both the ways in which the PNU and the ODM, in this case the two contesting political parties, and I'll quote here directly from his presentation, quote, organized, enticed, and or financed attacks against the civilian population, end quote, in furtherance of an organizational policy. So I note that I have 2 minutes, which is possibly more than I thought I had, but I'll perhaps close with, I think, where I started, with an emphasis on the importance of gravity as a limiting threshold, the underlying rationales, but also, I think, the deep definitional problems that we have, and I'm not sure, notwithstanding the fact that I've agreed to talk about this, I'm not sure how much closer the treatment by either the Office of the Prosecutor or the judges in the situation in Kenya, I'm not sure how much closer it takes us to a more fully elaborated definition. It tells us very clearly that the situation in Kenya meets the threshold, but it doesn't provide us enough nuanced assessment to really get a sense of what might not meet the threshold in this case. And I think that this is a question that is going to recur, not least because of the very strong objections around, by Judge Cole, who obviously will not be the judge in the actual trials, but I think he has laid out a very important question about how we think about organization, and I think this runs across very clearly crimes against humanity, very clearly gravity, and in different ways the assessment of genocide. So I'll stop there. Thank you.
Thank you very much, Chandra. Picking up from Chandra, Sarah, the point of gravity being used as a tool to select cases, and within that, of course, ensuring that the court uses its resources effectively. It brings us back to Article 17, and one of the threshold criteria being, of course, not only gravity, but also complementarity. And your talk to us is about the paradox of complementarity. And in 2003, the prosecutor issued a policy paper on policy issues before the Office of the Prosecutor addressing the principle of complementarity, in which he said the principle of complementarity represents the express will of states parties to create an institution that is global while recognizing the primary responsibility of states themselves to exercise criminal jurisdiction. The principle is also based on considerations of efficiency and effectiveness, since states will generally have the best access to evidence and witnesses. Moreover, there are limits on the number of prosecutions the ICC can bring. And of course, the prosecutor has been quoted as saying in the past that the effectiveness of the International Criminal Court should not be measured only by the number of cases that reach the court. On the contrary, the absence of trials by the ICC as a consequence of the effective functioning of national systems would be a major success. You say there's a paradox on complementarity in the way in which it has been applied under Article 17. Why is there a paradox, and where are the absurdities or inconsistencies?
Thank you. I think there are paradoxes everywhere. And I think the quote already illustrates three paradoxes I had in mind when I came here. First of all, the paradox of complementarity is a cornerstone. Everybody talks about the cornerstone of complementarity. But in fact, if we read the Rome Statute very carefully, complementarity is decoration. And this is even more so the way it has been interpreted in the case law, and the way it has been applied so far makes the role very limited. And I will explain why in a minute. But let me first give away the other paradoxes, because probably I won't have time to develop them, then at least you can ask a question if you're interested in them, to develop them afterwards. The second paradox has also to do with this quote that you mentioned, because the prosecutor refers to a primary responsibility of the state. And that's indeed the idea that underlies complementarity, that states go first. They have the first bite of the cherry, but also the responsibility to investigate and prosecute. Now, the paradox is, and I call this the normative paradox of complementarity, that by, on the one hand, creating an international criminal court that needs cases, and on the other hand, not incorporated in the Rome Statute a substantive obligation to investigate and prosecute on states. There's a reference to it in the preamble, but the preamble doesn't create an obligation, and it's not adjudicated by the court. So not obliging states to actually fulfill that responsibility, the court has been transformed from a court of last resort into a court of convenience. And this is what we've seen with all the self-referrals. That's the second paradox. Now, the third paradox is actually in the word complementarity. There's nothing to complement in a particular case. It is competition. In one particular case, it's either the ICC or the domestic justice system. Now, but what is happening, if you read very closely the OTP statements, it's actually using the word complementarity in its literal meaning. We are here to complement. We will do the big fish, and then the domestic justice systems can complement us doing the small fry. But this is not complementarity. This is the old-style primacy of the ICTY and the ICTR. Now, these were the three paradoxes I thought of when I came here. But actually, when I walked into this room, I saw a fourth one. What is the name of the room that we're sitting in? The Mandela room. Now, the Mandela model of justice, so much praised. Mandela is the only saint we have that is alive in the world at the moment. I mean, that we all agree upon at least. The Mandela model of justice is not possible under the Rome Statute, at least not the way it has been interpreted over the past years. Everybody in the world unanimously praised Mandela, perhaps a few victims in South Africa not, but the rest of the world was praised Mandela for this system of justice. And a few years later, what do? We all accept a Rome Statute that doesn't make that form of justice possible. What went wrong? And here, this is a kind of a question that actually goes beyond bashing Ocampo. I mean, there are many reasons why you can criticize what the cowboy prosecutor, but it's far more problematic. The problem is not resolved by replacing one prosecutor. The problem is structural, and the structural problem is in the Rome Statute and the model of justice. And here I also have a question for Africa, because Africa has been a serial ratifier of human rights treaties, and including probably the Rome Statute. But did Africa really think about what it's ratified when it's signed? Or was it just another human rights treaty that you signed because you want to be part of the international community of states? Now, and that's perhaps a warning. At the moment, the same thing we risk happening with this expansion of the jurisdiction of the African Court of Human and People's Rights. Because it's beautiful that the African Court of Human and People's Rights thinks about extending it with criminal jurisdiction. But read the draft statute. The model of justice, true, this morning it was mentioned that there will be more crimes, fine. But the model of justice is literally copy and paste from the Rome Statute. So where is the inclusion of the tensions that Africa has faced between peace and justice? Where is the South African model in that statute? It's not there. It's just the African ICC version. And that's actually, I think, where there's a huge challenge now for Africa to show its alternative ways, not just of doing justice, but of integrating justice and peacemaking. And Pliny has already said, out of Africa there's always something new. And afterwards the colonialists used it in a horrible way. But I would encourage Africa now to use it in a positive way and show that it has a method and an alternative vision, a richer concept of justice. Anyway, this was my advocacy talk. To the extent that I now have time left to actually go into some substance, I will start with the first paradox, and then let's see where we end up. Now, complementarity, cornerstone of the Rome Statute. I mean, that was the first that everything was writing already before the ink had dried on the Rome Statute. But and it's also, why was it a cornerstone? Because it was considered to balance two fundamental things, international justice and sovereignty. And it was always also the difference with the ICTY and the ICTR. And it's in that vein that Prosecutor Ocampo defined the success of the court as this court without cases. And this was and is, to a large extent, still a discourse on complementarity. But here comes the lawyer. Don't believe the discourse. Read the Rome Statute. Who of you has the Rome Statute with them today? Where is it? I see 1, 2. I rest my case. The problem of the discourse about the ICC is that we do it on the basis of discourse, talk. We don't actually read. And that's also even the problem with many states in Africa that signed. They thought this is another human rights treaty. Let's sign it because it must be good. We have to read it before we get trapped. Now, for those who didn't bring it, I brought it. And then we see immediately a few of the myths about the Rome Statute, and we have to read this Article 17 in the bigger context. The first myth is that the Rome Statute actually obliges states to investigate and prosecute. There's no such obligation in there, apart from the preamble, but the preamble doesn't create obligations, because if it had really been an obligation, it would have been important enough to put it in the body of the treaty. So it's just a preambular recital, just as aspirational as that we all want peace, love, and harmony. Now, the second myth is that complementarity is, I will walk back in a second, is situation-based. You know, if a state does something about impunity, then the ICC will not intervene. No, look here. The case is being investigated and prosecuted. Now, what does that mean? That in a situation of war crimes, crimes against humanity, there are thousands of cases. Theoretically speaking, if there's one case that the prosecutor can find that the country itself is not doing, the ICC can intervene, because there's always a case. Okay? So complementarity in that sense is very difficult to use to keep the ICC outside. Third, we all know the slogan. What is complementarity? The first thing is, if a state is unwilling or unable, the ICC intervenes. Wrong. The first 80 words of this sentence are ignored. Because the first question is whether the country is actually investigating or prosecuting. Only if the case is being investigated or prosecuted does the question arise whether the state is able and willing to do so genuinely. That's why all of the cases until Gaddafi have been about the question whether there were actually investigations going on. In none of the cases, not Congo, not Sudan, not Kenya, has the question arisen whether the country concerned was willing and able. That's also why this word case is so important. Now, and the way complementarity has been totally undermined is because the word case has been interpreted that you need to have the same person, the same incident, and the same conduct. What is the result? The result is that the prosecutor of the ICC has all discretion in the world. For instance, with Lubanga, who was domestically investigated for genocide and crimes against humanity, the ICC prosecutor can decide, I just do 3 crimes of war crimes. He has the discretion. But once the ICC is in, domestic discretion is gone because you have to follow the ICC model. Otherwise, not the same case is being investigated and prosecuted. Now, finally, and then I leave the other 2 paradoxes for another moment, is we all think about, at least that's the discourse on complementarity, it's the protection of sovereignty in the fight against international impunity. But the way the court has reinterpreted complementarity is not as balancing sovereignty and international justice, but if you read in the Kenya admissibility decision, and this was the pre-trial chamber, it talks about the exercise of national criminal jurisdiction by state is not without limitations. So it's no longer the primary right of states to investigate and prosecute. No, that right is limited. In other words, the way sovereignty is conceived is as limited sovereignty. And so it's not anymore that sovereignty is a check on the pursuit of international justice, what complementarity was initially conceived of. But sovereignty is only sovereignty, or sovereignty is protected only if the sovereign state joins the pursuit of international criminal justice. I'll leave it here.
Thank you very much, Sarah. You put out a lot of food for thought, which I'm going to pass over to Karim to try and answer.
Well, the easy response when there's food for thought is that time is needed to digest. But I think it was a very thoughtful presentation. And it raises a lot of points. But before we get to that, I think I would like to touch upon something that was said in the morning to put this in context. When we're focusing on complementarity and the allegation of selectivity, we can't deny reality. We are living in a very unequal world where there is massive, pervasive disharmony and division between the haves and have-nots. There is economic and social injustice and criminal injustice, criminal acts can't be removed from the wider context. It can't. But balance is needed when we're looking at the focus of today's discussion, namely the efficacy, the scope of the International Criminal Court. Because I don't subscribe personally to this group of practitioners and academics, political analysts, who simply would throw the baby out with the bathwater. It is far too convenient, in my assessment, to simply, and it makes good headlines, to dismiss the whole of international justice, the whole of the ICC, as neo-colonialist, as somehow racist, as somehow persecuting black Africa, as the colonial powers did in the past. That makes good headlines. It plays to sentiment. It plays to emotion. Whether or not it has any basis in reality, I think needs to be considered with very great circumspection. Because, and it was touched upon in the morning session, one cannot simply focus exclusively on the International Criminal Court and the cases, the African cases principally, that are underway there. One must look, if one is to be fair rather than political, upon how international courts, international accountability has grown, in particular since the Second World War. We have seen in Europe an assertion of judicial supremacy in practice. We have seen scrutiny not only at a domestic level, but at a supranational level by the European Court of Human Rights that is holding member states to account. That is taking place. This very country has, in numerous occasions, been held to be in breach of the European Convention. It is about accountability. It is about accountability. Now, just looking at the globe, look at East Timor. I defended there back in 2000, post-election violence also against Indonesia. United Nations was involved with the panels for serious crimes in East Timor. Go to Cambodia. I represented the victims there. Trials are underway in relation to the alleged atrocities by the leadership of the Khmer Rouge regime. Jump to the Middle East. Has that been given impunity? Well, look at the Special Tribunal for Lebanon. Whilst it is an offence of terrorism, let's see if the court expands its jurisdiction by the back door. But it is not, the rule of law has at least touched, the international elements have touched that area. And then look at the perhaps billions also spent by the international community right till today at the International Criminal Tribunal for the former Yugoslavia. So simply to say, well, this is racist and this is against Black Africa is to miss the point, in my opinion. It's to miss the point. But that is not to say that the ICC is not flawed, does not have problems to address when it comes to selectivity. But the selectivity that I think stares one in the face is not, as some commentators and practitioners say, Charles Taylor. Why Charles Taylor, not George Bush? Why Mr. X and not Mr. Y? It is actually selectivity within the continent of Africa. Why Bemba and not Petesi? Why Bagbo and not Ouattara? Why Taylor and not Blaise Compaoré? I mean, these to me, that's the issue of selectivity. And that feeds in, that political reality feeds into my analysis to an unfortunate reality. Whether it's the statute of the International Criminal Court, whether it's the Constitution of the United States, we have seen that any legal instrument, however beautifully drafted, needs judges, requires judges to breathe in life to it, to give meaning to what that instrument was intended to achieve. And that is just as much so in relation to complementarity. At the end of the day, it's about accountability. And that's why when one is looking at Article 17(1)(a), for me, a critical phrase is that states must be genuinely unable. The Rome Conference, the PrepComps, rejected, ineffective. They rejected many other forms. It's about sincerity. Countries trying to end this culture of impunity where civilians, the man and woman and child in the street, suffered the scourge of war. And that's actually what it's all about. The other issue, and you must tell me about the timing. One does, and the international community as a whole, need to try to make sure that one gets proper judges and a prosecutor of the right standard and with the right perspective in these very important positions. And my own view as an aside is that the term of office for the prosecutor is far too long. It's 9 years, and a lot of harm can be done to an institution, let alone the suspects and victims in a case by an errant prosecutor who's pursuing media headlines perhaps, or having a misconception as to his or her proper role. And I don't see any reason why the practice of the international community, when it comes to the ICTY and ICTR, where the terms typically are 3 to 4 years, should not be followed. That would allow other actors in the community to almost to decide, well, is this actually what we wanted? Is this, are we approaching this case in this institution in a proper manner? Now, one of the paradoxes and one of the unsavory aspects of the whole International Criminal Court as it's currently operating, it is, unfortunately, the prosecutor's perhaps expedient, opportunistic, or unprincipled position in relation to various issues. And the one staring one in the face the most, and it was mentioned this morning, is Libya. Everybody has seen on their TV screens a battered and bruised Colonel Gaddafi. We have numerous reports that are executed, numerous reports of former regime members who this government and the French government were very happy to sit down with and have dialogue with only some months ago. And those individuals are being tortured today. And what the court shouldn't do is that alleged war criminals be made somehow victims of complementarity. And I do put it like that, victims of complementarity, because the prosecutor's position, if you bear it down to its bare essentials, is that Kenya, a mature democracy, to give one example, with massive, massive constitutional changes, a real, I think, intent to change the actual architecture of the country when it comes to the appointment of chief justices and all the rest, can't be trusted. And yet a regime that has been internationally condemned for many decades, that has been a pariah, that has no pedigree in the rule of law or judicial independence, that unlike Kenya has no international act, International Criminal Court Act, the prosecutor is willing to say, no, we trust you, notwithstanding torture and the killing of Saif Gaddafi's father. We trust you to have that trial, but we do not trust Kenya. That is patently, one doesn't need to be a jurist. Common sense would militate in favour of questions being raised.
If you could just leave it there, Karim.
Okay.
Poignant thought, which I'm going to turn to Sir Geoffrey. Sir Geoffrey, you have been at the forefront of international criminal justice for over a decade. You have prosecuted one of the most infamous, should we say, leaders. You're now at a point where you're seeing, and we're all seeing, the winding up of the ad hoc criminal tribunals and the 10th anniversary of the establishment of the Permanent International Criminal Court. You've listened to the panel, you've heard what we've said, talked about this morning, and other panelists who talk about it's the International Criminal Court for Africa. The International Criminal Court was this great idea, this great aspiration to close the impunity gap, to bring justice for victims. My question to you, Sir Geoffrey, on the reflections on your past experience of the courts, the ad hoc tribunals, and for prospects of the future, is the International Criminal Court a positive development on the ad hoc tribunals? Is international criminal justice working? Are we going to see more prosecutions at the International Criminal Court rather than complementarity working, whereby the court reaches out and works with national jurisdictions to allow primary jurisdiction at the national level? In other words, is the glass half empty or is it half full, Sir Geoffrey?
Student groups have been visiting the Yugoslavian tribunal since it opened, to be addressed, amongst others, by the practicing lawyers. I would always start my talk to them by asking them what purpose, if any, was served by such a tribunal. Their answers were fairly consistent, and the word justice featured at an early stage in all of them. So I asked them what justice was, not because I had an answer, but because I didn't. And I am in the same position, but now, to some degree, having to face that same tricky question. And I suspect that we sometimes ask the wrong question. If we ask, is justice being delivered? And the appropriate question is one step removed. It's not whether justice is being delivered, but maybe what do systems of law that purport to deliver justice actually do for the people they serve? And there may be a developing second question: what can the people served by systems that purport to deliver justice do with those systems in their own greater, broader interests? A national justice system, if you go to the website of a Ministry of Justice or a prosecution service, will be narrow in its objectives, fairly. It will speak of writing laws, investigating, prosecuting, and punishing those who offend the laws, possibly with an additional comment about repeating, or reducing rather, reoffending. That may or may not match the citizen's concept of justice. Happy if it does, irrelevant if it doesn't. It may be, in a sense, a self-defining concept of justice. And it does not deal with the much broader issues that international justice systems purport to deal with when they look at reconciliation, perhaps impossibly hopeful dreams and ambitions. I'll come back at the end of my few words to the former Yugoslavia, but first of all just build in two tiny examples on the propositions I've advanced. What do justice systems do for the citizen, or even against the citizen? And nowadays, how can the citizen use those systems? We've already heard about Sudan, whose defense minister, recently charged and in the middle of conflict, the court arguably becoming an instrument of conflict itself. And that matter has also been eloquently touched on by Phil Clark. We were instructed, Rodney Dixon and I, by, as you've heard, the trade union movement, in circumstances where the president does not recognise the court. Our instructions, and everything is revealed in filings, every aspect of the way in which we've worked is there. Our instructions were, by use of the court mechanisms, to correct, to the extent we could, what might have been a lopsided, an extreme, an unfair presentation of evidence, and thus an unfair writing of a narrative by a prosecutor who was working according to the, some would say, primitive, inappropriate, adversarial system of trial that was imposed on these courts largely as an act of cultural imperialism by America and England and other such common law countries. So here you can see both how the court might be used as an instrument and how the citizen can react to it. The Libya case, in which we are also involved, again everything fully public, is another interesting example of the same two potential uses or abuses. Many would say that the early referral of Colonel Gaddafi to the court was part of an operation of regime change, quite independent of whether the time had actually been reached when the National Transitional Council should properly have been recognised by this and other countries. So the system was being used, not in the way a national justice system is being used when it's operated, but in a different way entirely. We were asked, on behalf of a friend of Saif Gaddafi, what can you do through these courts, if anything, to try and secure for him his basic human rights of a phone call to a friend or a lawyer or possibly a visit. So again, we have used the procedures of the court to get in on that friend's behalf, applications that ask the court to do everything it can, because it wasn't very willing to secure for a man who may be one of the most reviled on the planet, at least in tabloid newspaper terms, to get for him his basic rights. But the court was reluctant. Come to that, the National Transitional Council's lawyers are reluctant. Although they're the lawyers of record, they decline to be a conduit of communication to their principals, with whom, on Saif Gaddafi's friend's behalf, we cannot communicate. But we are trying. Back then, if I have a minute left or so, to the ICTY, which is further along many of the roads that these courts, other courts, have yet to travel, with many people convicted and coming to the end. Remember that not only have there been convictions and acquittals, but there has been in parallel the unsatisfactory for Bosnians case before the ICJ of Bosnia against Serbia for genocide. Take a step back. Ask not the question, does either of these courts deliver justice? But the one stage removed question, what do these systems of justice do, if anything, for the citizens of Bosnia, by way of example? What are their hopes? How are they met? Well, yes, if Mladic is convicted, that might well help them in a significant way. If it were possible to reopen the International Court of Justice case, despite technical difficulties, and get a verdict of genocide, that might also help them. But is the time coming when we have to recognize that what justice systems do is only part of what the citizen may want to be being done on their behalf? Because it may well be, take Bosnia, but what they really would like to have done is recognition, whether by a truth commission, which may be impossible, or by use of a court record and or in other ways. And the court process for them will be part of a broader series of activities, of recording history, maybe of having Russell-style tribunals and matters of that sort. Because on their own, whatever justice is, these legal systems do not necessarily deliver it. And I'll conclude with this observation. The citizen often enough complains that he doesn't like to be ruled by politicians. How much less attractive to be ruled in any great way by lawyers. The citizen must use the legal processes more and be cowed by them less.
Thank you very much, Geoffrey. Well, ladies and gentlemen, I think we've been treated to a feast of about food today, food for thought, of ideas and issues, paradoxes,